Okay, good afternoon. My name is Mark Gracie. Let's get this webinar going. I work for a business called Flavourfy Digital, and this webinar is brought to you in conjunction with myself and also Prodigy IT Solutions. So thank you very much for joining. Just to let you know that I am recording the session, so we'll make a recording available towards the end. There will also be the opportunity to ask questions towards the end. There's a questions section in the control panel which you can use to ask your questions. A few of you have been doing that already, and we can pick those up towards the end. I should speak for about 45 minutes, so we'll have a good 10-15 minutes for questions. So if you want to ask something, then use that question panel and we'll pick that up later. Apologies for the late starting. We were waiting for quite a few people to join in, but let's get started. So as I said, my name is Mark Gracie. I run a business called Flavourfy Digital. I provide consultancy around data compliance, and for obvious reasons, nearly all of my time, if not 150% of it, is taken up with GDPR right now. I also run an online service called the Digital Compliance Hub. I'll talk a bit more about that towards the end. But my background is very much in a regulatory environment. I have about a 20-year career, starting around the mid to late 90s when I became a data protection officer, when the Data Protection Act became law, and then, as I say, a 20 or so year career in regulation, mainly based around internet, but also data protection, data retention, and managing internal compliance and influencing external stakeholders. So what's the purpose of this webinar? It's all about GDPR compliance. The plan is to give an overview of data protection, an overview of the things that are changing with GDPR, so that you've got a good overview of what to expect and what you should be thinking about. And then hopefully you'll get a feel for whether it's something you need to worry about or what areas you need to worry about, and a few tips on how you can meet your compliance requirements going forward. So before we start, let's talk about data protection in general, just to make sure that we're all on the same page, and because I tend to start using phrases like processing and data subject and data controller, and they all need to be sort of defined and be clear that we all understand what this is all about. So before we talk about the changes coming with GDPR, I just wanted to talk about data protection in general. So the GDPR has, I think it's just over 40 different definitions, and in some areas they don't have enough definitions to actually offer some clarity about what things mean in certain contexts. But when we talk about data protection, there's 5 key definitions that it's worth understanding. So the obvious one is, what is data protection about? Well, it's about personal data. So what is personal data? Well, personal data is data that relates to any living individual, either directly or indirectly. And what that means is that if you have a pot of data that in itself doesn't have personal data in it, but it has identifiers or other data which you can link to personal data, maybe you've got a different database that's got, you're able to identify a particular person with that other data, then it makes both pots personal data. And it's any data that identifies the living individual. So that will be your client's data, that will be your employees, that will also be any people that you store and process data of relating to employees within a business. So even if you're in a business-to-business operation, any data you store about those businesses, if it identifies an employee within that business, then it too is personal data, and therefore data protection applies. In terms of the use of data, that's all about processing, and actually processing's got a very wide definition, and it's pretty much anything that you can do with that data. So it's not just about the use and why you've collected it in the first place and what you're going to use it for. It's the storing of that data, the manipulation of the data, the editing, the sharing, the deleting, the modifying, and so on. So if there's something you can do with the data, that's going to be your processing. And that's very important to understand, because there's some areas where whether you're a data processor or a data controller would have an impact on what that might mean, and we'll talk about some of that a bit later on. In terms of the key players, you have the data subject, whose data it is that you're collecting and processing. You have the data controller, which is the organization who is collecting the data from the data subject and determining how it's going to be processed. And that data controller may use a third-party organization called a data processor, who may process that data on the instructions of the controller. So for a simplistic example, in marketing, if you have a load of email addresses, the email addresses will be the personal data of the data subject. If you are collecting them, then you are the data controller. Now, if you pass that list of email addresses to a third-party marketing company for the purposes of doing your email marketing for you, you will be the controller and they will be the data processor. So those are the three key players when we talk about data protection. Now, in terms of the rules that apply, the Data Protection Act that we have right now and the General Data Protection Regulation talk about principles of data protection. I've used different colors to actually highlight that this is all relevant, but the Data Protection Act talks about 8 principles, which are the 6 blue ones and the 2 orange ones. The GDPR still has the orange ones, but doesn't define them as principles, and instead adds a 7th data protection principle called accountability. And I'll talk a bit more about that a bit later on. But in essence, these rules dictate what you can and can't do with data. So when you process data, you must do so in a lawful way. I'll talk about what lawful processing means in a moment. It also has to be fair and transparent. So you have to be open with the data subject about why you're collecting their data and how you're going to use it. You must only process it for the specific purpose that you're collecting it. And you need a lawful basis for processing if you want to process it in a different way. The data you collect must be relevant for the purpose for which you want to process it. So if you don't need to know postal address and date of birth, then you shouldn't be asking for that data. You should only be collecting the data that you really need to be able to process it to achieve whatever aims that you're collecting it for. You also have a duty to make sure the data is kept up to date. And typically that means if a data subject tells you that their postal address has changed, then it's your responsibility to make sure you update your records to reflect that change. You also need to tell any third party that you might be sharing that data with that they need to update their records as well. And when there is also an element of when the opportunity arises, you should be checking with your data subjects whether their data is still accurate and kept up to date. You must only keep data for as long as you have a lawful reason for processing it and continue to do it. So if you no longer need that data and there's no other reason why you must keep it and process it, then you must destroy it and delete it. So you should only keep the information that you need for the specific lawful purpose for processing. And as everybody knows, all processing has to be done securely, and there's specific rules around what that might mean in data protection. But basically, if you're processing data, remembering that processing covers everything from storage to sharing to editing to using for the purpose that you're collecting it, that all has to be done in a secure way. Now, individuals' rights, these are the rights of the data subject, and they range from things like the right to be informed to the right to erasure, and probably the most well-known individual right is the subject access request, which is the right to say, what data do you have on me, how do you process it, and can you have a copy? These set out the specific rights, and I'll be talking when I talk about GDPR about some of the ones that are new to data protection because of the GDPR, and some changes to the subject access request right as well. The international transfer rules say that you mustn't process or transfer data outside of the European Union unless you do so in a country that has adequate data protection. The EU has a list of countries that have adequate data protection, and I can tell you there aren't many of them. The most common example is if you're processing data in the US, you have to ensure that the US don't have adequate data protection, and therefore you have to look at how you can enable that adequacy or meet those requirements, and there's a privacy shield agreement between the EU and the US. So if the company is processing your data or you're processing your data in the US, you need to be signed up to the privacy shield. If that kind of arrangement isn't in place or isn't available, and the country doesn't have adequate data protection, then you would have to look at whether there's contractual terms you can put in place, and the Information Commissioner in the UK provides some standard contractual clauses that you should use in that scenario. But the bottom line on that is it is unlawful to process data outside the EU unless adequate controls are put in place. And then the accountability principle, I'll come to that in a moment. This is a new aspect covered by the GDPR in terms of what is expected of organisations that are processing data, so controllers or processors. Now, in terms of what we mean by lawfulness of processing, this is all about the lawful bases for processing, and there's a number that might apply. And you need to make sure that when you're processing data, at least one of these applies to your scenario, and also look at not by default going for consent, which is the top one. So if a data subject tells you that it's okay for you to process their data in that particular way, then that's your lawful basis for processing. You might require data for the purposes of delivering a service. So you've entered into a contract with somebody and you need their details for that processing. That would be your lawful basis for processing. You wouldn't need to ask consent. So don't always default to consent, because it won't always be relevant, and other lawful bases for processing might apply. So a typical example is if you are running an e-commerce site, you need to ask for a postal address to dispatch a product. You don't need to get consent to use that address for the dispatching of the product, because that's all part of the agreement that you need that address to be able to dispatch the product. You may be required by law or by regulation to keep data and process it for longer. So an example there is the taxman requires us to keep 7 years of tax records. So it would be lawful, even if you didn't need that data for anything else, to keep that data for meeting those tax law requirements. Similarly, in HR law, there may be a need to keep data for ex-employees for, say, up to 6 years, purely on the basis that that's the period by which they could take you to tribunal if they wanted to, and you need to be able to defend yourself. So it would be lawful for you to carry on keeping that employee data for that specific purpose, because the law allows you to do that and regulation requires it. And you may even work in a regulated sector that has its own rules about how long you keep the data for, and you know, the kind of things that you may be in the finance sector or in the care sector. It may be possible that you could claim that you're processing it in the interest of the data subject. That typically tends to happen in a life or death scenario for the data subject. So here we're sort of talking about a doctor seeing a patient and then feeling that the data subject might be putting themselves at risk, and therefore it would be lawful for them to share the data with law enforcement or other care services for the purposes of protecting the data subject. And if you're a public body, under some circumstances, you might be able to claim that you're processing the data in the public interest. So if there's a set of data that you need, and it's in the interest of the public to be able to process that data for public safety or for security and national security or whatever, then that data may be processed in the public interest. But that only applies if you're a public body. And then finally is this sort of woolly grey area called legitimate interests. It is possible for the controller to declare that they have a legitimate interest in processing data, but they have to be sure, and this is why it's a bit of a grey area, you have to be sure that there are no other lawful bases for processing. So if you could get consent, then that's what you should be doing. You shouldn't be using legitimate interest as a reason not to go and get consent. Likewise, if there's a legal obligation or it's required for the performance of a contract, then those are the lawful basis for processing. You're not using legitimate interests. The kind of things that you might use legitimate interest for is, for example, if you're chasing a debt, passing the data of the subject that you're going to be chasing the debt for to a third-party debt collection agency would be lawful, and it would be a legitimate interest of your business. You certainly wouldn't be asking consent, because you're probably not going to get it anyway. One of the ironies around data protection is, for example, in marketing, it is lawful for you to keep a list of people who have unsubscribed to your mailing list, so that you can make sure that they don't get back on the list by accident, and that would be a legitimate interest for that particular purpose, where there's no apparent harm to the rights and freedoms of the the data subject. The processing actually necessary? Is there an alternative lawful basis for processing? Is it harmful to the data subject if you were to process data in this particular way? If you're interested in legitimate interest and understanding that a bit more detail, there's a paper by the Data Protection Network, which has been signed off by the ICO, that has a lot of information about legitimate interest and when it may or may not apply. It also has a legitimate interest assessment, so that takes you through a set number of thought processes to enable you to understand whether legitimate interest is something you could rely on. So that's data protection from a sort of a basics perspective. If we now look at the GDPR and the General Data Protection Regulation, this fan diagram illustrates the 10 key changes that are coming with GDPR. The key date is the 25th of May 2018. That's when it becomes law. It's actually law right now. It's just that we're in a transitional period of 2 years. So it became law on the 25th of May 2016, and we've been given 2 years grace to make sure that we're all compliant by the 25th of May 2018. The key part of GDPR, or the key word, is the R, which is regulation, which in EU law terms means it applies across the whole of Europe, and it's not a directive. So the problem with the Data Protection Directive, which was implemented in the UK as a Data Protection Act, for example, is that different member states are able to implement the rules of the directive in different ways, which means that there's no level playing field across the whole of Europe. The point of it being a regulation is that it produces a level playing field, so a similar standard across the whole of Europe. So let's work our way through these 10 changes. So scope, as I said, it applies across the whole of the EU. So every member state has to replace its national law with GDPR, and they don't have to replace it per se, but it is applicable across the whole of the EU. There's a few derogations where member states are allowed to do things slightly differently, and of course, if a member state wants to be stricter than what the GDPR sets as a standard, then that's also applicable. So, for example, in the UK, the Data Protection Bill is currently being debated by Parliament, which essentially says the GDPR is part of UK law, even though they don't really need to do that. It's more of a thing that's useful for Brexit purposes. But also they're implementing some areas, or there's some discussion that they're going to be implementing some areas that are slightly stricter than what the GDPR implements. And also it implements a law enforcement directive, which talks about how law enforcement, so the police, security services, etc., how they process the data. The other thing to consider is it also affects non-EU businesses who are offering services and products to EU citizens. So if you were a US company providing services or products to an EU citizen, you would have to apply GDPR to their data. And in some circumstances, you'd also have to have a representative within the EU for the basis of being compliant. So a test would really be, how would you demonstrate that you're not supplying those goods and services to Europeans? And that might be difficult if you use English as your main language for your website. But if you were, for example, providing a website purely in Italian, it would be difficult for you to demonstrate that you weren't targeting Italians in Italy, which of course is within the EU. So if you were a business in a non-EU country, then don't think the GDPR doesn't apply, because I'm afraid it does. And from a definitional point of view, the definition of personal data is extended to include online identifiers. So if you've got IP addresses in weblogs which enable you to identify a user or a person within your system, then that IP address is also personal data, as is something like a Twitter handle or a social media handle of some other kind. So in terms of what constitute personal data, it's much more than just name, address, and telephone number or email address. It could be much wider than that. Now, the accountability principle I mentioned earlier, this is about one of the key factors of GDPR. It's about the data controller and the processor being responsible for demonstrating their compliance, and it's up to them. So it's up to the controller and the processor to be able to demonstrate that they are compliant. It's not up to somebody to demonstrate that they're not. What that means in reality is that certain Businesses, particularly if they process large quantities of data, have to document and record their processing activities because they may be quizzed on that at any particular time. But as a common principle, if you document everything that you're doing from your thought process in terms of how you determined how you were processing and data and your approach to various things like security and stuff like that, then that will go towards meeting this accountability principle. Because if you were able to demonstrate that you've thought things through, maybe even if you got it wrong, at least you're demonstrating that you're taking due care and attention when it comes to data protection. So accountability is a key aspect and change with GDPR. It's about you being able to demonstrate that you are indeed compliant and you meet the regulatory requirements of data protection law. If you provide services aimed at children, and these are defined as information society services, which is European legal speak for online services, and where consent is the lawful basis for your processing, so you would need to ask a child for consent as part of the service, for example, then you need to make sure that the messaging you're using is clear and understandable by a child, and you also need to seek consent from a guardian of that child as well. So depending on what you're offering and how your service works, you may have to consider how you're going to do some kind of age verification to make sure that whether you need to ask for that guardian consent or not. Now, the regulation defines a child as under 16. In UK law, it's likely, because of the data protection bill, that that the child will be defined as under 13, and the regulation, the GDPR, allows member states to determine the age of a child for the purposes of this part of the regulation. So in the UK, as I say, it's probably going to be under 13, although there has been, I'm not sure if they've decided that they will continue as they were, but there was some speculation that there was quite a strong lobby against it being as low as 13. So that's, as I say, just to repeat that's when you're offering an online service to a child and you need to ask for, or you're providing an online service that a child would be interested in, and consent is the lawful basis for processing. Now, on the subject of consent, of course, this is the area that everybody's getting a bit concerned about or excited about, because the consent rules are changing. Now, remember, this is about when consent is the lawful basis for processing. So this doesn't apply when you don't need to ask for consent. But where you do need to ask for consent, then you need to consider how you're implementing these new changes. So the new rules say that your messaging has to be clear and transparent. So the person who you're seeking consent for needs to understand what it is you're asking consent for and why you're asking for consent. And they have to take a positive action to actually give you that consent. So what that means in reality is, gone are the days of pre-tick boxes saying things like untick this box if you don't want to be marketed to, or double asterisks which take you to a very small print in terms and conditions, which use some woolly wording, which is a bit confusing as to whether somebody needs to tick or untick a box, or whether they are or not granting consent. If there's any doubt, then the consent won't be lawful, and therefore it'll be a breach of the GDPR rules. So clear and open and transparent messaging, positive opt-in. So tick this box or press this button to give us our consent. And you can't use wording like "we'll assume that you're okay unless you tell us otherwise," because that isn't, again, a positive opt-in. The other thing you have to do is you have to record when consent was given. So you have to be clear that consent was given through this mechanism, and the date and time which consent was attained. And the reason for that is that's all part of the accountability principle. So you're able to demonstrate that, yes, you did have consent, and this is when that consent was given. And what that really means is that in a sort of a typical email marketing scenario, obviously there's lots of different email marketing programs that are available, but something like MailChimp, for example, you could say, well, if you make use of MailChimp's double opt-in functionality, which may or may not be turned on by default, you're rubber stamping that consent, because as well as them filling out a form on your web page, they're getting an email that says, are you sure you want to join this list? They're taking an action to say yes they do, plus MailChimp will record the date and time. So provided you're able to identify that people on this list came via this route and they would have read this messaging and understood the privacy policy and all this other information, so that they understood what it was they're consenting to, that takes care of this consent mechanism. The other things to consider: consent is withdrawing consent is an absolute right. So an individual can say that they don't, they may have given you consent, but they've got a right to withdraw that consent at any time. So you need to facilitate how that might happen. So typically in email marketing terms, you have an unsubscribe button at the bottom of your email. And also you can't force people to give you consent. So you can't say, well, I won't do this for you unless you consent to us processing your data in that particular way. That would be unlawful. But the key thing is clear messaging and a positive opt-in, and record that consent is given, and make sure you allow somebody to withdraw consent. And just as an aside, it's worth looking at what you might be doing with your HR employment contracts, because if you're using statements like the sort of a typical HR contract might have things in it around that by signing this contract, you're agreeing to us using your data for the purposes of your employment, and also for anything that we feel that we might want to do with regards to your data for our business, then that wouldn't be a lawful consent mechanism. So you might want to have a look at how you're using consent within in things like HR contracts. Now, individual rights, remember I mentioned that this is one of the aspects of data protection that's been around for a while, and in the GDPR introduces a number of new ones, but also updates an existing one, a key one being subject access request. So starting at the top there, the right to be informed. This is a right that says that a data subject should understand who you are, what you're doing with their data, how long you're going to keep it, how they can complain about you, and so on. And there's two sides to this. There's the Article 13 requirements, which set out all of those things at the point at which you're collecting the data. And if you're provided the data by a third party, then Article 14 says that as well as that, you've also got to say where you got your data from, how you're going to use it, what you're going to do with it, and so on. So Articles 13 and 14 are about the right to be informed, and it's about providing enough information to enable to meet the regulatory requirement, but also to enable a subject to understand what it is you're going to be doing with their data and etc. These are the kind of things that you're going to have to put in your privacy policy. So you'll probably need to review your privacy policy to make sure that's up to date. Subject access requests aren't a new individual right, but they are changing. So under the current regime, you can charge £10 plus VAT, and you get 40 days in which to respond. Under GDPR, you can't charge a fee, and you get less time. You've got to do it within a month. Now, a subject access request, as I said earlier, is all about a subject's right to say, what data do you hold on me? How do you process it? What do you do with it? And can you have a copy? That's still relevant, but as I say, you can't charge a fee, and you get less time in which to deal with it. Now, if you're in a business who has a lot of subject access requests, then this might be a significant change for you, because I know from personal experience that when dealing with subject access requests, when you say £10 plus VAT for the privilege, that some people say, well, actually, I'm not that desperate for it, so I won't go ahead, in which case that was very much a barrier that was quite helpful, which is probably the reason why they've removed it. So there's a good chance that we might see a rise in subject access requests. In fact, some research done at the end of last year indicated that 70% of consumers now, knowing that they have the access to a free subject access request, are likely to file one when they probably wouldn't have done before. On to two new ones, the right to erasure, or the right to be forgotten. This is an absolute right, but it does allow a data subject to say that they want their data to be erased. It doesn't mean that they can tell you to delete their billing information so that you can't bill them. If there's a legitimate reason for you processing that data, so there's a lawful basis for processing, then you can continue to do so, and you wouldn't have the need to erase the data. But in certain circumstances, that right is available to a subject to use with regards to the data that you might hold on them. And of course, if you're only keeping data for as long as you have a business reason to do so, then it's unlikely that you'll be getting these requests to delete data that you haven't got anyway. And then finally, the other new right of data portability. This is a right that gives the data subject the right to say, I want a digital copy of my data exported from your system so I can import it into another system. And it also, the regulation says, where it's applicable to do so, the controller should facilitate that transfer automatically. So the kind of scenario I see that this is probably typically going to work, but this applies to anybody who's collecting data from data subjects and then processing it in an online environment, a digital environment. So it applies to anybody who's processing data where somebody could export that data and they'd have to deal with that right. But the typical scenario would be if you're trying to swap utility provider, you want to move from one provider to the other, you just press a data portability button within your customer portal access, and that exports the data over to the competitor. Excuse me. So those are the individual rights that are changing and some new ones. Now, another key area that will affect probably most businesses is the change to the controller-processor relationship. So this is about understanding whether you're a data controller or a data processor, and in some situations you might be a bit of both. But it basically, Article 28 basically says, if you're a data controller and you use a processor for the purposes of processing your data, you must only use a processor that can adequately demonstrate that they are GDPR compliant. And it also requires you, in Article 28.3, to set out specific contractual terms between you and the processor. So they range from very obvious things like only processing the data under written instructions through to having the ability to come and audit the processor if you feel that they haven't perhaps guaranteed their GDPR compliance. So if you're a controller using a third-party processor, you're going to have to carry out due diligence on that third-party processor. If you're the third-party processor, then you can expect your clients and users to be serving you with letters and notices saying that they expect you to give them a GDPR statement or some kind of statement of why your service is GDPR compliant. And between the two of you, you're going to have to organise these new contractual terms that have to be put in place. The key thing to remember, the definition of processing includes the storage of data. So if you're storing data in a CRM like Salesforce, HubSpot, Zoho, or you're storing your accounting information in something like QuickBooks, or you're using other cloud-based software, you're using Dropbox to store your data, you're using MailChimp for your email lists and so on, they are all examples of processors. And in this scenario, you need to carry out due diligence on those processors to make sure that they are GDPR compliant. And of course, the reason why I was talking about international transfer of data as well is that if those typically are US-based services store the data outside the EU, you need to be sure that they've signed up to adequate data protection protocols so that you can be sure that your data in their service is being processed within the GDPR law and rules. The other thing is, if you're a data processor, you now have responsibilities and liabilities which you won't have had before. So under the current regime, you pretty much, the buck stops with the controller, and under the GDPR, if the controller could demonstrate that the problem was with the processor, so the controller carried out the due diligence, the processor said everything was secure and was being processed securely and there wasn't going to be an issue, but then the processor had a data breach, it's possible that the processor would get the fine or the investigation rather than controller. So these are new responsibilities for data processors. So if you're running a cloud-based service, or if you're providing outsourced marketing or outsourced HR or outsourced payroll, you would be a third-party processor, and therefore, because of this regime change, you've got to think about this controller-processor relationship, the contractual obligations, and the fact that you have liabilities that you won't have had before in the past. Under UK law, we've had as best practice from the Information Commissioner's Office the concept of privacy by design and privacy impact assessments, but the GDPR implements them as part of law. So data protection by design and default is all about considering data protection and the rights and freedoms of the data subjects at the core and heart of what you're doing. So if you're coming up with a new way of processing data, or you're going to use a new system to process the data, you need to consider data protection ramifications up front and at the beginning of that process, not as an afterthought. And you can use a tool called a data protection impact assessment to actually work out whether you're GDPR compliant and that your processing is compliant with the regulations. In general, the DPIA is actually about high risk processing. So if you process particularly sensitive pieces of data or special categories as referred to in GDPR on a large level, so high numbers of data, or if there's particular high risk to the data subjects, then the chances are you need to be carrying out a data protection impact assessment now, as well as anything you might do in the future that might change. So data protection has to be by default, and you can use tools like data protection impact assessments to make sure that you're meeting the requirements of the regulation. And you might need to use a DPIA to demonstrate your accountability, so meet the accountability principle that you're taking this all very seriously. Some organisations are required to have what's called a data protection officer. Now, I was a data protection officer when the '98 Act came out, but that's a completely different concept. That was just a job title. In the GDPR, a data protection officer is defined as somebody within the business that's required to take responsibility for data protection on behalf of the business. Not everyone needs to have them. There's specific organisations that do. For example, public bodies must have them. In a general sense, if your core activity is the regular and systematic monitoring of data subjects on a large scale, then there's a chance that you will need to have a data protection officer. There is some guidance around this from the Article 29 Working Party, which is the European group of regulators. And it's worth having a look at that because it goes into detail about what core activity, regular and systematic monitoring and large scale mean, because those are three key areas that you have to consider that aren't actually defined in the regulation. So this piece of guidance might help you understand whether you fit the bill with those requirements. Of course, the obvious question is always, am I large? Am I processing on a large scale? I'm an e-commerce site that's making decisions about what it advertises to people on site based on their purchasing and things like that. Is that therefore systematic and regular monitoring? It probably is, but I'm not as large as Amazon. So does that mean that I don't have to worry about it? So it's those kind of questions you'll need to think about. I mean, in terms of scale, I suspect it's very much about looking at your demographics. So if you have 80% of a market in a niche market, then you're probably large scale, even if that's only 100 people, as opposed to a million or a billion. So if you do need to have a data protection officer, the regulation sets out the expectations of what that data protection officer should be doing within your organisation. They have to be registered with the local regulator, which in the UK is our Information Commissioner's Office. And the law is basically there to stop businesses telling the data protection guy to be quiet and not keep talking about data protection because it's annoying. It's actually to enable them to get on and do their job and make it a core part of their business, just as data protection by default and design is all about as well. So if you're in any doubt, have a look at the guidance. There are some examples in there, although if I'm honest, I've yet to come across a business where I've been able to say, yes, your business looks exactly like that example and therefore you need one or you don't need one, because they don't go far enough in my opinion, and we're hoping to get some more examples where it might be a bit more helpful. Another new aspect of the GDPR is data protection breaches. So if you have a breach, under some circumstances, if there's a risk to the data subjects, you have to tell the regulator, so that would be the Information Commissioner in the UK. And if it's a high risk to the data subjects, so things like there's a chance of identity theft or fraud, or that maybe medical records have been breached or other special categories of data, then you would have to tell the subject as well. So not only are you telling a regulator that you've had a problem, but you're also having to tell your clients and customers that you've had a problem too, which is sort of a double whammy with regards to your people's views about your business. There are some regulated industries like telecoms, for example, that already have this requirement, but this now applies to everybody. And even if you decide not to report something because you don't think it meets the criteria, you still have to record that, because you may be asked to demonstrate that you have or haven't had any breaches and what decisions you made about a particular breach. And the concept here is to try and avoid the kind of Uber situation where, I don't know if you heard about Uber, but they had a massive breach a couple of years ago, but they tried to sweep it under the carpet and be quiet, and it got out. So they're not only having to deal with the fact that they've breached UK data or European data protection rules because they had a breach, but they're also having to look at they're being investigated because they tried to hide it as well. And it's also worth noting that a breach isn't just your sort of traditional atypical hacking. It's accidental deletion, accidental change, or the editing of data. It's even unlawful viewing. So in theory, or sorry, I should say in practice, somebody looking over your shoulder, reading your screen while you're looking at your customer database is a breach, because somebody who doesn't have isn't authorized to view it is actually viewing it. So all those kind of things count as a breach, and therefore we need to bear that in mind. And then finally, the thing that lots of people have been beating on about, because it's all so terrible, is that the fines are coming. They're being made to be much larger than they've been for some time, and the top level of fine is 4% of global turnover, or 20 million euros. In all fairness, and the Information Commission has been very open about this, that GDPR isn't about the fines. It isn't about fining people 4% of global turnover or 20 million euros. It's actually about a case-by-case proportionate investigation, and you can see that with some of the things that they're doing under the Data Protection Act. So if you look at the TalkTalk or the Carphone issues where they had breaches, they got fined the maximum under data protection. The maximum under data protection law is for $500,000, but they got fined 400K, but they were the largest fines to have ever been issued. So even those kind of breaches weren't treated as at the top level. And then you compare it to something like the National Health Trust that shared data with Google DeepMind AI, with a view that if patient records can be used by artificial intelligence to come up with better patient outcomes, then that's in everybody's interest. They had documentation, they worked it all out, their lawyers had talked to each other, and they concluded that it would be implied by the patients that if they could get better patient care, then why not use AI to do it? The Information Commissioner said, no, that's all horribly wrong, but nobody got a fine. And that's because they were able to demonstrate that they had gone through some checks and balances. They might have got that wrong, but and being told that they got to put some steps in place to make sure that they rectify the situation. But nobody got fined. Now, considering that's the NHS, Google, a global corporation, and special categories or sensitive data, because it was health records, it's a real surprise that nobody got fined. But that's a demonstration of how the Information Commissioner thinks about these two sort of extremes. So that's GDPR in a nutshell, and very much a whistle-stop view of the 10 key things that are changing. Clearly, that will mean a lot to your businesses in different ways. Things that might impact your business more than others are things like the controller processor, and where are you processing your data retention, and consent, particularly in a marketing environment. But I just wanted to sort of give you a few pointers as to what compliance might look in a general sense. Certainly from a practical and pragmatic perspective, there's a number of different things that you can look at and look at within your business. If you can, first up, appoint somebody who can take responsibility, somebody to act as a data protection champion, or be the data protection officer, even if it's not a mandated one, within your organization. Will have a single point of contact or a focus point within your business to ensure that everybody knows who to go and speak to if they've got a question, rather than getting it wrong themselves, and somebody who can be sure that the business is keeping on top of everything when it comes to ongoing compliance. The thing lots of people talk about is carrying out an audit, and that's certainly a great place to start. If you can look at what you've got right now in terms of data, systems and policies, and work out where you need to be, then that's a good step in the right direction. But in terms of meeting your accountability requirements and your demonstration of compliance, then document everything, document your decision making about why you've decided to do things in a particular way, because that might be the bit that helps avoid a hefty fine, or even a fine at all, if you can demonstrate, like the NHS Google example, that you've thought this through. And even if your thought processes were wrong or you were advised wrong, it might give you a bit of leeway to play with. If you can, provide internal documentation, because if employees understand where they can read about what they should and should be doing with data, then that's going to help. And of course, train your staff about the internal documentation and guidance and the policies. And so, sorry, I forgot to say, have policies in place so it's clear what your position is within your business. But if you train your staff to understand you have these policies, that data protection is an important part of your running your business and the role that they have to play in it, then that will help empower a culture across your business about knowing who to speak to if you've got a question, and also mitigating any particular risky scenarios where they might be going off and doing the wrong thing because they haven't been told otherwise. But the important thing, and I'll come to this in a couple of slides' time, about maintaining your compliance and keeping up to date. This is about this not being just about GDPR and the 25th of May. Data protection and ongoing compliance goes way past the 25th of May. You will need to make sure you're on top of everything. Now, in terms of an audit, I tend to think about these stages, and I've already sort of mentioned them. First one, prepare yourself, get your business to have a buy-in in terms of needing to do something. Audit your data systems and policies, compare it to where you need to be with your data systems and policies. So understand the GDPR and where you need to get to be GDPR compliant with those data systems and policies, which will enable you to then deliver an action plan, which will include training the staff and empowering everybody to play their part. And then you've got this ongoing compliance, which, as I said just a minute ago, is about managing data protection into the future, not just about being ready for the 25th of May. So the kind of things you're looking at is being able to deal with users' rights. So if you get a subject access request, how do you deal with that? Making sure your security is still adequate, making sure your staff understand what their responsibilities are, because you've got policies, you deliver training, refresh those policies to make sure they're current, refresh the training, or at least remind your staff about what training they need to, remind your staff through training or refreshers about why data protection is important, and a general review of your approach and making sure that you're up to date. Now, the problem with keeping up to date is there's actually quite a lot to be kept up to date with. So not only do we have the GDPR coming in a couple of months, well, about 3.5 months time. As I mentioned, there's a data protection bill that might implement some more stricter data protection aspects within the UK, as well as implementing GDPR. If you're using marketing data, you also need to pay attention to the e-privacy regulations. So we have the Privacy and Electronic Communication regulations from 2003. As part of the law, they set out what you can do with cookie data and also what you can do with electronic marketing. But these rules are changing as well. The original plan was that they would come into force on the 25th of May, so the same time as GDPR, but at the moment that's looking unlikely, and we'll probably see something towards the end of this year or next year, which ties in with what might be happening with Brexit. So we're due to be leaving Europe next year, but there's this question about a sort of 2-year transition and what that might mean, and how does that impact on international law and EU law and data flows. The UK government have written to the EU and said, let's pretend as far as data flows are concerned that nothing's changing, but the EU are not indicating that they firmly agree. So if we suddenly are seen to be outside the European Union from a data point of view, then we may have to demonstrate our own adequacy. So if you're processing European citizens' data in the UK right now, the Brexit ramifications for data controls may be quite significant. The middle two hexagons there are about guidance. So we have the Information Commissioner who are producing guidance and updating existing guidance, and the Article 29 Working Party, which are basically the ICOs across the whole of Europe, also produce guidance, and between them there's quite a suite of different bits of guidance that are here now or coming or being currently consulted on. There's some consent guidance, for example, from the ICO and from Article 29 Working Party. There's some data protection officer guidance on Article 29, and also data protection impact assessments, just as an example. And then finally, there's the enforcement angle. If a member state interprets the regulation in any particular way, then that might have ramifications across the whole of Europe, and therefore what might happen locally in the UK. And of course, when we Brexited as well, we've got to understand what that might mean for us in the UK, not being part of Europe, but whether we apply European standards going forward. So there's a lot to keep on top of, and in some ways there's a bit of a sort of a depressing end to the presentation, so apologies for that, but that's really where I can come in. So very quick sales pitch. So as well as providing consultancy services where I help businesses with audits and by the hour consultancy and training and outsourced data protection management and officers, I also run an online service called the Digital Compliance Hub, which is a way to be rest assured that you've got access to resources, information and guidance, and also a helpline should you need help at any particular time, either leading up to 25th of May or into the future, and keeping on top of what's going on. And the good news is that if you take up the Prodigy IT security package service, the Digital Compliance Hub is bundled as part of that, as well as also access to some of my time from a GDPR consultancy point of view as well. So if you're thinking about how does this all impact your business and you want some help and advice, then have a look at the Prodigy IT security package and see what that's how that might be able to help you not only meet your security requirements, but also get you access to the kind of support and help you might need on GDPR. And as I said, this slide's just all about my consultancy services. So I help businesses look after their GDPR and data and privacy compliance. Which brings us to the end of the presentation. Thank you. Sorry, it was such a whiz through quite complex areas, but if you want some more help or you've got any questions, then contact details for both myself and Prodigy are on screen now. But now's the time that if you've got any questions, we'll try and pick those up in the questions panel. So please use that to ask questions. I've got a few things here. Let me just have a look. Okay, right. So first up, Roseanne's asking, is it necessary to issue new contracts to staff with a strengthened privacy policy, or is an amendment sheet sufficient? So there's no dictation in the law that tells you what way you've got to do it. You've just got to make sure that everybody understands the new principles and the new approach. And so, yes, an amendment or an addendum to an existing contract or updating your privacy policy would be sufficient. You wouldn't necessarily need to reissue everything. So you can probably find some sort of contractual terms that you can add as an addendum to existing contracts, for example. Okay, next question from Alan. So having received a website lead, we then pass these on to our distributor network, which is USA or India, for example. Do we need to check for consent to send the contact details to these distributors? So you won't necessarily, so it depends on the circumstances. If you are asking for specific, so if you need to carry out this as part of your processing, then you wouldn't need to ask consent. But if these are cold leads and you'll need to look at the privacy rules and what they say, then you would need to ask for consent, and it would have to be GDPR consent. In a B2B environment, it's slightly different, so that's why I say check out the privacy regulations. If you go to the Information Commissioner's website, they've got lots of stuff around PECA and the privacy rules that will tell you when you do and don't need consent. If you are passing that information, regardless, to the USA or India, then you need to carry out due diligence on that distributor network if they're going to be doing some processing for you, because you need to be sure that they're GDPR compliant. So that's that one. Sorry, I've just managed to lose my questions. Here we go. Right, so gosh, we've got quite a few questions to get through, so I'm going to whiz through them. The webinar was due to finish at 4 o'clock, which I'm conscious is any minute now. I'll keep running for a little bit longer, and because of the recording, you'll get the answers to these recorded as well. If I don't get through all of them, then I'll make a record of them and perhaps ping people the answers separately. But Will's asking, saying he's running a small web design agency and he's confident about getting business compliant. Do they need to audit every single client site they've built in 9 years to ensure they're compliant and raise any issues with those clients? So if you're talking about things like consent pages and things being accurate and GDPR compliant, then really ultimately that's down to your clients. The kind of things that you need to think about is the controller processor relationship. So you'll be the processor of their sites, and therefore if their sites are collecting and processing data, then you would be the data processor, they would be the controller, and that's an area where you need to think about making sure you've got a GDPR statement and that you've got these contractual terms in place. But in terms of the compliance of your clients' websites, that's really down to your down to your clients to make sure that they've got it right, and they will be doing that. Obviously, you might do that as a service to help them as a sort of value add. If you wanted to sort of stand up against the competition and say, well, we do all of this for you, and if only you were one of our customers, then you wouldn't have to worry about these kind of things, that kind of thing. And in terms of whether it could legally come back and bite you, well, the question there is, if somebody has audited you as a client and said, is my website compliant, and you said yes, then that becomes a sort of a damages kind of situation from a legal contractual term. So it's worth looking at it, but generally it's the controller's responsibility, but you as a processor have duties that you have to honor when it comes to that controller processor relationship. And I think be more focused about making sure that your processing on their behalf is compliant as much as anything. Right, interesting question from Anthony. How can we control staff having personal email addresses or personal details on the details on their laptops and desktops? The answer to that is it's difficult to control that, perhaps technically, and there's situations where sometimes people email themselves data to go home and process, and there's lots of examples where that's gone horribly wrong. There was a case involving a care home. One of the staff took their some care records home for a patient, and it was stolen from their front room while they were in the house. Their house got burgled, and the records got stolen, and that was a breach. And the company I think got fined about 70k because of that, because adequate security wasn't put in place. So it's about looking at how can you control from a sort of a policy point of view, as opposed to looking over all your employees' shoulders every 5 minutes to make sure they're behaving themselves, by instilling a culture within your organization that your employees understand the risks of the fact that if they copy data themselves, then they could be putting themselves at risk. And there's plenty of examples where members of staff have gone to prison because they blatantly misuse data or, in that kind of scenario. But generally, in terms of protecting your business, educate your staff, make sure they understand the consequences, maybe talk about the fact that this is a term of an employment, and it will be considered a disciplinary action if something was to go wrong. How are we doing? So, God, there's loads of questions. Thank you for all of this. I'm going to answer a couple more, and then I think I'll have to get back to the other unanswered ones via email. So Wayne's asking about collecting email addresses of professionals manually through websites in the past and sending a monthly newsletter. Do you need to get consent for that? Well, what you need to look at there is a different set of rules, which are the Privacy Electronic Communication Regulations, which actually say when you do need consent and when you don't. In a very simple wrap up of that, if you're dealing with cold leads that are individuals or sole traders, you need consent, and it will have to be GDPR consent. If you're dealing with people you have a business relationship with, you need to have asked them whether they want to opt out or not, but you can mark it to them. If you're doing purely B2B, so that's limited companies, PLCs, LLPs, etc., you don't need consent, but in all situations, you need to have the ability for them to opt out. So if they tell you to stop, then regardless of whether they're B2B or B2C, you need to make sure that you honor that withdrawal of marketing. Yeah, check out the Privacy Electronic Communication Regulations. It's another regulation that the Information Commissioner regulates, and there's some marketing checklists which sort of set out the different scenarios of what you need and under what circumstances. And the second part of that question was about using systems which give you the opportunity to include a button to unsubscribe. Is this breaking rules? No, you have to provide the ability to allow somebody to unsubscribe or opt out of your marketing, and therefore you should provide it in a way that is convenient to them and also works for you as well. But they can typically withdraw consent in any particular way. So if they ring you up and tell you to stop, then that's withdrawing consent, even if they haven't chosen to use the unsubscribe button. But yes, you do need to provide the facility to opt out. So having an unsubscribe button isn't breaking the rules. Okay, so it's 4:05, so we've overrun by 5 minutes. What I'll do is I'll make a record of the questions that are outstanding, and I'll ping answers very quickly in emails to those people. Thank you very much for joining. We'll be in touch with a link to the slide pack and also a recording, so you'll have the answers that I've answered, and also the stuff I went through as well. So thank you very much. Enjoy the rest of your day, and good luck with your GDPR preparations.